Hello friends, welcome to Legal Lexum. So before going into further, if you are new on my channel or you didn't subscribe my channel yet, then please like it, subscribe it and share it so that you will get all the future videos from time to time. So friends, today in this video I am going to discuss with you a topic of restitution of conjugal rights, which has been provided under section 9 of the Hindu Marriage Act. So conjugal rights means basically matrimonial rights. Each one of the parties to a marriage has a right to society and consortium of the other parties. And when this basic right is broken by the spouse, the other party has a right to relief under this section. Suppose you are a husband and your wife has leave the societies without any reasonable cause, and your wife started living with her, in her laws house, parental house, then what's the remedy available with you in law? So you can file a petition under section 9 of the Hindu Marriage Act and mentioning all the circumstances as to why your wife has been started living in her laws and left your matrimonial home, and why she has left the society without any reasonable cause. So basically conjugal rights means matrimonial rights, that is the rights of the parties to a society and comfort of each other. The word society means companionships, cohabitation, that is consortium, living together as a husband and a wife under the same roof. So in a very popular case, that is Saroj versus Sudarshan Kumar Chadda, in this case it was held that the objection of the restitution decree is to bring about cohabitation between the estranged party so that they can live together as a husband and wife. Now we see what the petitioner has to prove before filing petition under this section. Either this is husband or she is wife. Then the first thing she or he has to prove that the one of the spouse has without reasonable cause left the society of the other. Means if one of the spouse has left the society of the other, thereafter the other is going to file a petition under this section. Second point, there are no reasonable grounds for doing so. Means there are no reasonable grounds as to why the other spouse has left the society of the one party. Third ground, petitioner must assure the court that the case stated in the petition are true. It means the petitioner must have to prove in court that the facts which has been stated by the applicant in his petition is true and why a decree of restitution of conjugal rights has been granted. So in this case, if a husband file a petition under section 9 of this act for restitution of conjugal rights as to directing her wife that she has been living in her parental house or with her in-laws, so the court, after going through the petition, taking all the petitions and seeking replies, the court will pass a decree for restitution of conjugal rights. Even if thereafter, after filing a petition, a wife didn't come back, then it itself becomes a ground for divorce under this section, and thereafter the husband can seek divorce on this ground itself, that after having passed a decree of restitution of conjugal rights, the wife didn't come back and didn't join her matrimonial home. So friend, it's very important to know that this right can't mostly used by everyone because mostly are unaware of it. So if next time it can be doing so in your nearby future on your neighbor, then you can explain any other person regarding this right, that section 9 is available under the law for restitution of conjugal rights, and everyone can seek in remedy in this act if the other spouse has left the society of the other without any reasonable cause, or if there is any other reason. So friends, I hope you must like today's video, and if you like this video, please like, share and subscribe it so that you will get all the future videos from time to time.